All right. Well, thank you for joining us this afternoon. We are here to talk a little bit about the New York City amendments to the New York City Earned Safe and Sick Time Act, but just a few housekeeping items before we actually get started with the substantive presentation. Like always, if you have any question that you would like to submit to the panelists, please feel free to submit those questions through the chat function down below or the Q&A function down below. Also, please, after we're done today, take some time and let us know how we're doing and complete the survey and send it on back to us so that we can continue providing as best of a service here as we can. So we appreciate the feedback and we would ask that you send that over to us. And with that, we will move on to the actual presentation. And so today's webinar will be presented by myself and my colleague, Teresa Rosnack. I'm Jessica Moeller. I'm one of the attorneys in the Garden City and New York City offices. Teresa is one of our attorneys in the Rochester office, and we are happy to be here with you today. And we're all here to talk about these amendments to the New York City Safe and Sick Leave Act. Now, I know over the past several months, we've all been hearing a lot about the different changes that are being made and being implemented at the state level with the New York State Paid Sick Leave Law. But we haven't had as much discussion about what is going on at the city level. And not surprisingly, around the same time when the New York State Paid Sick Leave law was coming into effect, at least as far as accruals were coming into effect on September 30th, we see Mayor de Blasio signed into law amendments to the New York City Earned Sick and Safe Time Act. And those amendments that we're going to go through today were largely meant to bring the New York City law into compliance with what is being implemented at the state level. And so you'll see as we go through, there is a lot of overlap between what we're talking about now on the city level, as well as what you've all been hearing us talk about and working with your staff about in terms of getting into compliance with the New York State Paid Sick Leave law. But there was also some significant changes on the city level to the New York City law that were unrelated to the law that's coming into play at the state level. And so we're going to talk a little bit about those city-specific amendments as well, because you need to be aware of both those that are going to overlap with the state law and those other changes that are being made, which are specific under the New York City law. And so let's dig in here. And so one of the very significant changes that has been made to the New York City law, but is not surprising because of what is being implemented at the state level, is the New York City law has amended the definition of who is an employee for purposes of coverage here. Previously, as I'm sure everybody is aware, in order to be able to be eligible for and be covered as an employee for the New York City Earned Sick Leave benefit, an employee had to work within the confines of New York City for at least 80 hours within a calendar year. So if I only periodically worked, a few hours here and there, and I never crossed that 80-hour threshold, then I did not previously become within coverage for the New York City law. That is now changed. So effective as of September 30th of this year, under the city law, an employee for the purposes of this act is all of your employees, regardless of the number of hours that they work, regardless of the number of hours that those work hours are within the confines of New York City. If it's, I work 5 hours or I work 80 hours or I work 1,000 hours within New York City, I am going to be covered for purposes of the New York City Earned Sick Leave Law. One of the other fairly significant changes that was made to the New York City's law also deals with what employers are covered and what the employer's obligation is with regard to providing sick leave, whether it be unpaid for certain employers or paid sick leave for certain employers. Now, previously, the law said, and again, this is the New York City law, said that if I was an employer with fewer than 5 employees, I did not have to grant paid safe and sick time leave to my employees. I would have to provide unpaid safe and sick time to my employees, but it didn't have to be paid if I had fewer than 5 employees within my company. However, the law has now been changed so that similar to the law at the state level, if I'm an employer with 4 or fewer employees and an income of less than $1 million, or $1 million or less, I should say, in the prior tax year, I have to provide up to 40 hours of unpaid safe and sick time leave to my employees. If I'm a slightly larger employer with 4 or fewer employees, but my net income is more than $1 million, so that $1 million net income is the threshold there. If I earn more than $1 million for my company in the prior tax year, the 40 hours of time that I need to provide to my employees is going to be paid. So we now see there's that distinction between those small employers with fewer than 5 employees needing to provide paid or unpaid sick leave, whereas previously it was only unpaid leave. So that is another significant distinction, but again, not surprisingly, because it is consistent with what we're seeing at the state level. The next change that everybody needs to be aware of, particularly those larger employers, is where an employer has, excuse me, where an employer has 5 or more employees, there's now also a change. So previously, the law said that if it was 5 or more employees, what I had to do was provide 40 hours of paid safe and sick time leave to my eligible employees. Under the new law, there's a split. So we now have this group of sort of medium-sized employers with 5 to 99 employees working for the company. It's that medium-sized group of 5 to 99 employees who now must provide 40 hours of paid safe and sick time to their eligible employees. For employers that are larger, with 100 or more employees, now that larger group of employers needs to provide up to 56 hours of safe and sick time. So essentially, it has increased from providing 40 hours, essentially 5 days of leave for most of our full-time employees. Now it's been bumped up to essentially 7 days, 56 hours of safe and sick time that I need to provide to my employees if I'm in that larger employer group. Just back one slide, please. The next change that has occurred again, not all that surprising in light of the change that we just spoke about, is dealing with how much amount of leave do we have to allow employees to carry over. So previously, the law said that where you were in that group of employers with 5 or more employees, you needed to allow your eligible employees to carry over up to 40 hours of their accrued, unused, safe and sick time. Not surprising. However, that 40 hours that employees in the large group of 100, the employers with 100 or more employees, that 40-hour amount that employees could previously accrue has now increased to 56 hours. And so we see a similar change now in what employees are allowed to carry over for that large employer group. So if you're an employer with 100 or more employees, now it's not just 40 hours that you have to allow your employees to carry over. Now it's 56 hours of accrued, unused, safe and sick time that employees must be permitted to carry over. Of course, there's a little tweak, which was always the case with the law, both before and consistently now, even after these amendments, is that if your practice and your policy as an employer is to front load the time for your employees and provide the full benefit that an employee could accrue during the calendar year, you front load that and make it available to them on the first day each year. So as of January 1 of each year, they have their full allotment of benefit that they could use. If you front load in that sense, then you don't need to allow the additional carryover of previously the 40 hours, now currently and going forward, the 56 hours for that larger group. So it's always important to keep in mind the potential to, at least for the city law, to potentially not need to do the carryover by front loading the time for employees. That might not ultimately make all that much of a difference if you know, because of some of the issues that we're seeing with the leave being implemented at the state level, but at least for purposes of the New York City law, if you front load, you don't need to deal with that carryover. The next change, again, very consistent with what we're seeing on the state level with the paid sick leave law that we've all been talking about. At the New York City level, there was also some changes with regard to whether somebody has a waiting period before they're able to use their accrued time. So previously, under the New York City law, an employer had the right to impose a 120-day waiting period, essentially 4 months, before an employee would be allowed to use their time. Under the revised law, and consistent with what we're seeing at the state level, there's no longer that 120-day waiting period. So if I'm an employee and I accrue my time, even if I'm very new, a month in, a week in, you know, as long as I've accrued some amount of leave, I am able to use it as it's accrued. I no longer have to wait that 120-day period before I'm able to use my accrued time. Now, there's a couple of things just to note on this. You see there on the slide under the special notes. First, because because of this change that has been implemented for the different employer size groups, it's been implemented sort of right smack dab in the middle or towards the end of the year when we've already done a lot of what we needed to do in terms of keeping in compliance with the law. And so for these employers that are now needing to provide, for example, more time, the larger employer group with 100 or more employees needing to go from 40 hours up to 56 hours, the law has built in the ability, at least for 2020, that even though employees can accrue and even though employees will ultimately be able to use come January 1 of 2021, they will be able to use their full allotment of 56 hours for that large group. Essentially, given the timing of where we are, the law gave us a bit of a safe harbor in putting that into place now. And so even though ultimately the number is going to bump up to 56 hours for that large employer group, for 2020, we're able to limit how much time somebody can actually use this year. And we are only needing to allow up to 40 hours of use this year. It's going to change come January 1, but at least for the time being, in terms of use, we're okay if we stick with the 40-hour number. The other issue here is with regard to employers who have 4 or fewer employees and the net income of $1 million or more. Accrued time for employees in that employer group can't actually be used until January 1st. And that I think was because for up until this change in the law, employers with 4 or fewer employees only needed to provide unpaid time. So the law builds in a little bit of a safe harbor there in employees in that category not being allowed to or not being able to use their time, their accrued paid time until January 1 of next year. So that's another big change that we're seeing. With that, I'm going to turn it over to Teresa to talk a little bit more about some of the changes that we're seeing on the city law that don't necessarily tie in to the changes that we've seen at the state level, but are nonetheless very important to take note of. So, Teresa?
Thank you, Jessica, and good afternoon, everyone. Thank you for being with us. As Jessica said, while she focused on the changes that were going to make the New York City Earned Sick and Safe Time Act consistent with New York State paid sick leave, I'm going to talk more about some of the additional revisions that New York City made to the Earned Sick and Safe Time Act that, do to a certain extent tie into New York State paid sick leave, but aren't necessarily designed to be consistent with that act, especially as we're still getting guidance under that act as it develops. So the first one to mention on this is documentation. So as most of you are probably familiar with, the Earned Sick and Safe Time Act allows employers to request documentation sufficient to support an employee's need for leave if that leave is 3 days or longer. I know a number of you have this in your policies, and going through your policies, I've seen that many times. And that's not changed when it comes to the revised law. What is changed is that the revised law mandates that employers pay for the cost of producing that documentation when an employer requires the documentation from the employee. So, and this really has to do more with, sometimes you go to a doctor's office or to a court and they say there's going to be a charge for copies or a charge for printing out your medical record or a charge for sending it. That's the type of administrative cost that the law is saying that employers now must cover if an employee is going to be charged that either from their healthcare provider or from the court or from whatever entity they need to get their safe time documents from. So that's just one change. So the employer now is on the hook for that fee to the extent it requires those documents. And again, you're allowed to require those documents to support need for leave that's 3 days or longer. Another big change, probably a bigger one than just that documentation change, was on the pay statement. So now, under the revised law, employers must include on pay stubs or other form of written documentation provided to employees each pay period the amount of earned sick and safe time accrued and used during that pay period, and the employee's total balance of accrued earned sick and safe time. So, on this, I do think this is, for those of you that aren't already putting this information on your pay stubs, this is going to be a bit of a change for you. This is certainly something I would encourage you to work with your payroll department or payroll provider on getting this in place. Now, as Jessica said, this law did become effective on September 30th, except for the couple of tiny exceptions that she mentioned that take place the first of the year. But I will say, for this pay stub requirement or pay statement requirement, the Department of Consumer Affairs has posted informal guidance on its website saying that it won't enforce the pay stub requirement until November 30th of this year, provided that an employer is working in good faith to comply with the pay stub requirement. So for those of you that are worried because this law has been in effect for almost a month and we don't have maybe the right information on their pay stubs or the right information on written documentation given to employees during each pay period, that's something that you do still have a little bit more time to get into place. I will say though, given that November 30th is only slightly over 30 days away at this point, and especially with the holiday in there, a couple holidays in there, you may want to start working on that sooner rather than later, especially because working on it right now would be a way to show that you were trying to comply in good faith, should you be ever asked to submit proof of that. So that's one of the changes. There's also a posting requirement. So the notice of rights is something that I'm sure you're all familiar with, because we've had the notice of rights under the Earned Sick and Safe Time Act for a bit now. But the revised law requires employers to post that notice of rights in the employer's place of business in an area accessible to employees. And that's the language from the new law. So I would interpret that to mean in an area where you put your other posters, right? All your other required postings. This notice of employee rights now needs to go up there as well. The update of notice of rights must also be provided to employees at the time of hire, which you already had to provide that notice of rights, but now you have to provide the updated notice of rights. And then for those who already hired, that needs to be provided by October 30th, 2020, which is 30 days after the legislation became effective. I did check right before we started this presentation. The updated notice of rights is not yet out. We will be sure to update you on when that does happen. Hopefully soon. Otherwise, we're not going to be able to comply with the October 30th deadline, because October 30th is right around the corner. So New York City may publish that, very close in time to October 30th. So I urge you to just keep an eye on that. And certainly that's something that we'll keep an eye on as well. But as I said, I checked right before this webinar started, and the notice of rights was still the one that was being used from 2018. So we do not have that yet. The new law, or the revised law, actually does quite a bit on retaliation as well. It expands the definition of retaliation. So for those of us that are familiar with the Earned Sick and Safe Time Act, and really any type of leave law in New York State, we know that you can't retaliate against someone for using leave or expressing their rights under that act or helping someone else do the same. So this just expands that, kind of significantly, although probably not in a way that I would argue wasn't already in place. It's now just explicitly saying that you can't take an adverse action against an employee that penalizes an employee for, or is reasonably likely to deter an employee from exercising or attempting to exercise their rights under the Earned Sick and Safe Time Act. We now may have a causal connection between the protected activity and the retaliation, which can be shown by either direct or indirect evidence. So that's just something that was explicitly codified in the law. The new law also includes an explicit list of adverse actions, and I don't think that this is necessarily meant to be the entire universe of adverse actions, but it is a number of things that the new law says explicitly are adverse. So threats, intimidation, discipline, discharge, demotion, suspension, harassment, discrimination, reduction of hours, informing another employee of an employer of an employee's exercise of rights, blacklisting, and then adverse attendance policies, so punishing people for taking time under the Earned Sick and Safe Time Act. And then the law does have an explicit provision saying you can't take action against an employee regarding their immigration or perceived immigration status as a retaliation for something they did with Earned Sick and Safe Time Act. The protected activity under the new retaliation standard need only be a motivating factor for the adverse action. So even if there were other non-protected factors that contributed toward the decision that you made, that's still something that isn't going to save you. As long as the protected activity was a motivating factor, you could be in trouble retaliation-wise. The law also provides that employees who mistakenly, but in good faith, assert their rights under the Earned Sick and Safe Time Act may not be retaliated against. So that's if someone makes a good faith complaint, it turns out the complaint doesn't have any merit, the employer actually didn't make an error, that person still can't be retaliated against on the basis of that complaint. So enforcement is one of the other things that's covered by the new law. The revised law allows the Department of Consumer Affairs to investigate violations on its own initiative, as well as upon the receipt of an employee complaint. So that's been the case for a bit, but now it's explicitly codified. The revised law also allows the department to seek relief, not just for the complainant or the person making the complaint, but for each and every employee or former employee who was affected by the violation. So relief can be on a more widespread basis than just the individual employee, assuming that the violation applied to several others. And then penalties will be on a per employee basis. And then finally, for domestic workers, those of you that have domestic workers, and I know this won't apply to all of you or even most of you, but for those that it does, I just want to mention it briefly. Domestic workers have had a significant expansion when it comes to the Earned Sick and Safe Time Act. This is the definition that's been placed into the law for domestic workers. It's any person who provides care for a child, companionship for a sick, convalescing, or elderly person, housekeeping, or any other domestic service in a home or residence. The prior law said that domestic employers who worked for the same employer for at least 1 year and more than 80 hours in the calendar year could earn 2 days of Earned Sick and Safe Time Act. The new law is a significant expansion of that. Domestic employees, regardless of employer size, financial condition, or number of hours worked in a calendar year, can accrue up to 40 hours of Earned Sick and Safe Time Act at a rate of 1 hour for every 30 hours worked. So that is a pretty significant expansion. And if you are a domestic employer or work with domestic workers, I urge you to reach out to counsel on that, because there has been a significant sea change with regards to domestic workers. So some tips for employers, and I know we are at about at 12:30. So please update your policies as soon as possible. Remember that there is a policy requirement. Integrate Earned Sick and Safe Time with New York State paid sick leave. I think if you can, you should. It's a good idea, especially with the new Earned Sick and Safe Time being revised to be consistent with New York State paid sick leave. Look for the revised notice of rights to distribute, and then the poster that's going to come along with that. And then please, as it concerns your pay stub requirement, if that's the route you're going to go, or if you're going to go with some other type of written documentation, you'll want to work with your payroll providers or payroll department on that. All right, Jessica, did you want to answer any questions that came in, or did you want to just wrap things up here?
Sure. So there were just a couple of questions that we can quickly answer. One, just for purposes of clarification, these amended changes and the additional benefits that are being discussed today, just to make it crystal clear, these are amendments that were made to the New York City law. And so if you are outside of New York City, and you as a company and your employees are outside of New York City and elsewhere, operating elsewhere in the state instead of within the confines of New York City, we're happy to have had you here with us today, but fortunately for you, you really won't have to worry about these particular amendments, because this is an amendment, or these are amendments to the New York City law. So we did have a couple of questions about that. You will still have to deal with the law going into effect or in effect at the state level. But at least for these amendments, you know, you'll be a little bit off the hook there. Another question that came in is with regard to the effective date. And again, just to make it as clear as we can, the majority of these amendments that we have spoken about today really do take effect, or did take effect, as of September 30th of this year. There were those couple of very minor provisions that don't take effect until January 1st. Those being the two things that I believe I spoke about regarding employers with 100 or more employees providing the 56 hours of paid leave. That's going to take effect, and the use of 56 hours or up to 56 hours takes effect January 1. And also the issue of the smaller employer group with 4 or fewer employees who have a net income of $1 million or more providing paid leave. That is taking effect come January 1st. But everything else that we've spoken about with regard to these amendments, those all went into effect as of September 30th. There is that slight delay in enforcement on the pay stub issue that Teresa noted, but technically even that has now already gone into effect. So if you haven't come into compliance yet or worked on that, I would suggest you know, trying to work on trying to you know, get all of these things into compliance. That is all that I had on my end. So unless Teresa has anything else, we will say thank you very much for joining us. As always, we are very, very pleased that you're willing to spend some time with us and learn a little bit about these developments in the law. And we will do our best to continue keeping you updated with everything. Stay well,
Thank you,
everybody.
everyone.